Jeff, thanks so much for taking the time. I appreciate you doing this.
Thanks for having me on, Dimitri.
Now, before I get into some specific questions about wrongful convictions, about your specific case, tell me a bit about you, who you are, where you're from, and what happened to you when you were 16 years old.
So my name's Jeffrey Deskovic. I'm an attorney. I'm the founder of the Jeffrey Deskovic Foundation for Justice, which frees wrongfully convicted people and pursues policy changes aimed at preventing those injustices from happening. So far, we've freed 14 people, helped pass 6 laws. I'm located in Bronx, New York. I started the organization because when I was 16 years old, I was arrested for a murder and rape, which I did not commit. The city was Peekskill and the county was Westchester here in New York.
Tell me a bit about your case, how you were arrested, how you were prosecuted, convicted, and ultimately how you had that conviction vacated over time.
So the year was 1990. I was 16 years old. I was a sophomore at Peekskill High School. The victim was 15 years old. She was an immigrant from Colombia. She was living a very sheltered life as I understood it. She never went anywhere unless she was accompanied by her older sister or her parents. She was in two of my classes as a freshman, one as a sophomore. I knew her name. She knew mine. That was really the extent of it. We weren't even really on a high-buy basis. There hadn't been a murder in Peekskill for approximately 20 years, so this really shook the community up. There was parents were concerned their own safety of their children. There was plenty of rumors. There was a general fear in the community. Parents were driving their kids directly to school and then picking them up right after school. So I got on the police radar because in high school I was quiet. I was to myself. I wasn't really like in the in crowd. I was on the fringes of the high school society. The kids there were all like 1 year older than I was, and I really wasn't into what they were into. I wasn't into going to parties or drinking or chasing girls, so I was a bit of an outcast. And so in the course of the police investigation, they interviewed a lot of students from the school. Some of them told the police, "Hey, you might want to talk to Jeff." So that's how I got on their radar. A follow-up factor was I was a sensitive teenager, and this was my first brush with death, and I had an emotional reaction to it. And the police thought that, given that I barely knew the victim, that the emotional reaction was suspicious. Although in a larger sense, I wasn't all that different from the rest of the people in the city of Peekskill. I mean, it really shook everybody up to the point that free mental health services were offered to anyone who wanted it. So those are the two factors that I got on the police radar. A reinforcing factor was the Peekskill police got a psychological profile from the NYPD, which purported to have the psychological characteristics of the actual perpetrator, and I had the misfortune of matching those characteristics. So a reinforcing factor. Prior to becoming a teenager, I dreamed about being a cop when I grew up, and the police learned about that. And so my interactions with them over the next 6 weeks, it was kind of like a cat and mouse game. They would start out each interaction questioning me like I was a suspect, and when they would push too hard and I'd become frightened and want to get away from them, Jeff as this junior detective helper theme was developed. Look, the kids won't talk freely around us. They will around you. Let us know if you hear anything. Stop in from time to time. They would ask me opinion questions and congratulate me that my opinion was correct. I came from a single parent household. My father was never involved in my life in any aspect. And that also intersected with a different police tactic, the good cop, bad cop, Mutt and Jeff, in which one officer takes on a more aggressive role. The partner pretends to be a friend. So I began to look up to the good cop as a father figure. Eventually, they got me to agree to take a lie detector test, otherwise called a polygraph test. They said, look, we got some new information in the police file. We want to share that with you. That's going to allow you to be even more helpful to us. First, though, you have to take and pass the polygraph. So the next day, rather than report to the high school, I went to the police station for the test. My mother and grandmother thought I was in school since it was a school day, hence they didn't call around looking for me. They drove me to the town of Brewster, which was in Putnam County, so 40 minutes away by car, which meant I wasn't able to leave on my own. I was totally dependent upon the police. There were 3 cops that came with me from Peekskill. Then there was also the Putnam County Sheriff's investigator, but he was dressed like a civilian. He was pretending not to be law enforcement. He never read me my rights. He gave me a 4-page brochure which explained how the polygraph worked, but it had a lot of big words in it that I didn't understand. But I figured, well, since I'm there to help the police, what does it matter? Let's just get on with it. I didn't have an attorney present. They didn't give me anything to eat the entire time I was there. He put me in a small room. He gave me countless cups of coffee. Seems clear in hindsight the purpose of that was to get me nervous. And then he attached me to the polygraph machine. And then he launched into his third-degree tactic. So he raised his voice at me. He invaded my personal space. He kept asking me the same questions over and over again. And he kept that up for 6.5 to 7 hours. As each hour passed, my fear increased in proportion to the time. Towards the end, he said, "What do you mean you didn't do it? You just told me through the test result that you did. We just want you to verbally confirm it." And that really shot my fear through the roof. And at that point, the officer who had been pretending to be my friend came in the room and told me that the other officers were going to harm me. He had been holding them off, but couldn't do so any longer, that I had to help myself. Then he said, "Look, just tell them what they want to hear. You can go home. You're not going to be arrested." Being young, naive, frightened, 16 years old, I wasn't thinking about the long term. I was just concerned with my safety in the moment. I was in fear of my life because the fact that I didn't know where I was and no one else knew where I was either loomed rather large in my mind. I was overwhelmed emotionally and psychologically. Then there was the push-pull dynamic, the possibility of harm, the false life preserver. And so I made up a story based on the information which he gave me that day and a 6 weeks run up to it. By the time it was all said and done, I had collapsed on the floor in a fetal position, crying uncontrollably. Obviously, I was arrested. I was charged with a murder and rape. So before the trial, there was a DNA test result which excluded me. There was seminal fluid found in and around the victim that didn't match. But rather than acknowledge they made a mistake, they continued to prosecute full speed ahead. In order to explain away the DNA evidence, the prosecutor got the medical examiner to commit fraud, commit perjury. When there's an autopsy that's done, they do written and audio notes, which as they make their findings. So it was only 6 months after doing the autopsy, only in response to the DNA not matching me, that the medical examiner said that he remembered that he forgot to document medical findings, which he claimed showed that the victim had been promiscuous, which is what opened the door for the prosecutor to argue that that was how the DNA didn't match me, and yet I was guilty, that she was sleeping around, that in fact she had slept with somebody else before I murdered and raped her. Taking it a step further, he mentioned another youth by name that he claimed slept with the victim, but he never set the proper evidentiary foundation for that. So he never got a DNA sample from this other individual, never even called him as a witness. He just made the unsupported argument to the jury. At the same time, my public defender essentially didn't defend me. He never interviewed or presented as a witness my alibi. I was actually playing wiffle ball when the crime happened. He never explained to the jury the significance of the DNA not matching me. He never used that to argue that that proved that the confession was coerced and false. He literally asked no questions of the medical examiner. And in addition to that, he should have never represented me because of a conflict of interest. So this other youth that the prosecutor was falsely saying had slept with the victim was represented by another member of Westchester County Legal Aid, and specifically by the lawyer who was supposed to be supervising him on my case. So that conflict prevented us from asking him for a sample. It prevented us from calling him as a witness. When you defend a case where there's a confession, you have to answer that confession. You have to explain it. You have to disprove it, bring it all together in your closing arguments. But my lawyer didn't do any of that. Sometimes he argued to the jury the confession never happened at all. Other times he told the jury that the confession was coerced, and still other times he said it was false. So he had to have been standing there with no credibility at all. I wanted to testify because the interrogation had not been video or audio taped. There was no signed confession. It was just a cop's word for it. And when they came to court, they left the threat and false promise out of their story. But he wouldn't allow me to testify. He said it wasn't up to him to prove that I was innocent. It was up to the prosecution to prove I was guilty, and he didn't think that that had happened. While that's a legal principle, that's, it's a naive way to practice law. There were two irregularities that I'll briefly mention, which, in connection with my trial. So firstly, polygraph polygraph results are not admissible in court because it's not scientific. And, in fact, even intelligence officers are trained on how to beat the polygraph. But the judge created a backdoor rule. He allowed the polygraphist to repeatedly tell the jury that I failed when I denied committing the crime. He said, well, this alleged confession happened while you were being polygraphed. So that was definitely prejudicial. And then in addition to that, the victim's bra, along with her other clothes, had been entered into evidence. The jury asked to see the bra. And that was important because in one of the statements they coerced out of me, I said that I ripped her bra off. And some bras, the way that they're made, you can't rip it off. So when the jury asked to see it, that's when the judge said that the bra and other clothing items had been left in the courtroom over the weekend and that the janitors thought it was garbage. And so it had been thrown out. It was no longer available. He substituted a picture in which he said you could almost see the bra in the photo with the actual bra. On the third day of the jury deliberation, they sent out a note. They asked, well, if we can't come up with a verdict, will we be sequestered over the Christmas holiday? And the judge said yes. And at that point, it was 11-1. We were all pressing the one juror, and they didn't want to be kept there over the Christmas holiday, so he switched his vote based on that. And so I was wrongfully convicted of a murder and rape. I had been charged and tried as an adult, so I was sentenced as an adult. I was given a 15 to life sentence where I was sent to Elmira Correctional Facility.
How did you go about vacating that conviction? And explain the difference for folks who may not know the difference between what they call here in New York a 440 motion, right? A motion to vacate, and a traditional appeal.
Yeah, so the difference between an appeal and a 440 motion. So an appeal, you're raising legal issues that already appear on the record. In the 440 motion, you're saying, I'm going to introduce facts that are not on the record. So I'm going to expand the record and then make new legal and factual arguments based on that. So in terms of how I was exonerated, well, let me ask you a question. You want me to just tell you how I was exonerated, or do you want me to walk you through the appeal process and then how I was cleared? What do you prefer?
Both.
Okay. Went to the appellate division in the direct appeal, the first court one must go to. My lawyer argued my innocence. That was revolved around the legal issues of legal insufficiency, that the prosecution hadn't proven guilt beyond a reasonable doubt and weight of the evidence. My Fifth Amendment rights had been raised, the manner in which I'd been questioned. The polygraphist issue had been raised. The evidence issue, evidence being thrown out was raised. The judge being biased was raised. In total, there were 10 issues of law that were raised. And the appellate division, they wrote that I was free to come and go as my own, as I wanted. So therefore, the statements were voluntary. They ruled that there was overwhelming evidence of guilt, which is kind of a head scratcher considering the DNA didn't match me. The only thing they had is this coerced false confession under questionable circumstances. They rejected the polygraphist issue. They said, well, I put that in issue. And lastly, they got rid of all my other issues in one sentence. They wrote that they looked at my remaining contentions and found them either to be without merit or else not preserved for review. They ruled against me 5-0, and it was all downhill from there. The re-argument motion was denied in one word, denied. The Court of Appeals declined to give me permission to appeal to them. I lost the habeas corpus petition because my lawyer was given the wrong information by the court clerk pertaining to the filing procedure. So my petition arrived 4 days too late, which former Westchester County District Attorney's Office, Jeanine Pirro, her office took the position that those 4 days were prejudicial. So they argued the court should just rule I was late and dismiss my case. And that's what they did. I challenged that ruling at the Federal Court of Appeals. I got permission to appeal the procedural issue to them. But future U.S. Supreme Court Justice Sonia Sotomayor and her colleague, Judge Rosemary Pooler, they upheld that ruling. My lawyer moved to re-argue it, requesting all the judges on the circuit hear the matter and vote en banc. And that was denied. And the Supremes declined to give me permission to appeal to them. So at that point, my appeals are exhausted. Only way you're back in a court would be if there's a retroactive change in the law, or number two, if I find some previously unknown evidence of innocence, which probably would have led to a different outcome. I didn't have money to hire an investigator and an attorney, hence a letter writing campaign looking for pro bono services. I wrote letters for 4 years. I went to the parole board largely because I maintained my innocence rather than expressing remorse and taking responsibility. I was denied parole. I wound up doing 1 additional year, being 16 in all. One of the letters that I wrote to an investigator, which was in care of the publishing company, I wrote the letter to the publishing company trying to reach a book author, but they sent it instead to an investigator. And so when she saw the DNA didn't match me, she was convinced of my innocence. She never saw a case before where there was an exculpatory result and yet a conviction had resulted. And she gave me ideas, and one of them was the winning one. She suggested that I write the Innocence Project again, which is a nonprofit organization in Manhattan that frees wrongfully convicted prisoners in cases where DNA evidence could potentially demonstrate innocence and in which no prior testing had been conducted. I wrote them originally back in 92, 93, but because the DNA was already in front of the jury, it wouldn't have been new. So getting the test results and then presenting that to the court under a newly discovered evidence argument wasn't an option. Fast forward 15 years, the investigator said, look, in light of the DNA data bank being created, the prior denial is irrelevant, so write them again. I did that. And about 6 months later, they got back to me and they told me they were taking my case. So that was the first key. Second key was that Pirro left office and her successor was not as dug in. As I understand it from the rumor mill, neither one of them liked each other that much. And Pirro was in the middle of running for attorney general. So I think that I was given the test in the hopes that I would be exonerated and, damage her run. But whatever, I'll take it. And the third thing is we got lucky that the actual perpetrator's DNA was in the data bank. So we took the crime scene DNA evidence and entered it into the data bank, and it matched the actual perpetrator whose DNA was only there because left free while I was doing time for his crime. He killed a second victim just 3.5 years later after killing the victim in my case. The victim was a school teacher and had 2 children. So on September 20th, 2006, the conviction was overturned. I was released. Went back to court November 2nd, 2006, at which point all the charges were dismissed on actual innocence grounds, and the actual perpetrator was subsequently arrested and convicted and pled guilty for the crime.
Why do folks confess to crimes that they didn't commit?
Sure. So firstly, it's more common than what people think. Of course, false confessions have caused wrongful convictions in 29% of the DNA-proven wrongful convictions. And while adults have given false confessions, particularly vulnerable people are those with mental health issues and youth, with which I was a youth. So I think just being overwhelmed, being frightened, certainly being lied to. I mean, being told you can go home afterwards is a common theme in these false confessions. So I would say all those things. And for me, added on would be just the threat. Certainly the length of the interrogation, it was 6.5 to 7 hours. When coupled with food deprivation, it wore me down.
Now, you and your foundation obviously does these cases a lot. What do you see as the more common reasons that wrongful convictions take place? Is it scientific evidence? Is it a false confession? Is it bad lawyering? Is it a combination of some of those things?
It's a combination. So prosecutorial misconduct is a factor that runs through many of the cases, but also coerced false confessions, misidentification, lying informants, bad lawyering, certainly tunnel vision. Other factors could be forensic fraud and sometimes junk science. So things that have previously been accepted as evidence in court that have a scientific air about them, but are not actually scientific. Things like bite marks, tire tracks, footprints. These things are not scientific because there's no underlying studies to demonstrate what the error rate is. Arson science is another. It's not actually a science at all. It's just verbal traditions that are passed down from one fire chief to another.
Prosecutorial misconduct is kind of this catch-all phrase that could mean a whole lot of different things. Prosecutors in this country are afforded, depending on what level you're on, a degree of discretion, right? And we afford prosecutors that discretion because we as a society have determined that we need somebody to make judgment calls as to how we prosecute folks, what evidence is turned over, what we charge, what we offer as a plea. Do you see prosecutorial discretion as a general concept being problematic? And how do we fix it if we do? Is there some oversight that can be implemented to deal with these kinds of things?
So I don't see prosecutorial discretion as an issue. I see prosecutorial misconduct as an issue. So my misconduct, I'll put some color to it. So withholding evidence of innocence, something that's supposed to be turned over under what's called, Brady. So that suborning perjury, not correcting perjured testimony, improper opening remarks or closing arguments, or even offering, evidence in that's not admissible, whether previously ruled as such or not. So those things cause wrongful conviction. So I think I see immunity as being an issue. My solution, I would say, is a number of things. So firstly, Prosecutors do have they do have immunity, and which means you, no matter how egregious the wrongdoing is, if they commit that while after an arrest has been made, they have immunity. So I advocate removing immunity. And if it for clear-cut intentional misconduct, then I think that you should be able to sue the prosecutor. Now, their pushback argument is, well, we want them to prosecute criminals, not defend lawsuits. We want people to be able to concentrate on their cases, not look over their back for a lawsuit. I reject those arguments because police officers are not hindered from doing their jobs, but you could still sue them. The same thing with forensic scientists. The only thing they need to do is don't commit intentional misconduct. So removing the immunity is one thing. Second thing is myself and my colleagues in the coalition group, It Could Happen to You, aided by many other organizations, we helped pass a landmark bill in New York referred to as the Commission on Prosecutor Conduct. So it's an independent oversight board that has the ability to investigate allegations of prosecutorial misconduct. So our hope is that it would, number one, people who have been victims of misconduct would have a forum to go to for potential legal redress. And secondly, we hope that it would perform some type of deterrence effect, that prosecutors would hesitate in committing misconduct. And thirdly, I think that when a prosecutor purposely withholds evidence of innocence, and that results of in a wrongful conviction, I think that they should be subject to criminal charges. But again, we're not talking about gray areas. I'm not talking about cases of discretion. I'm talking about clear cut and intentional. The same way, by analogy, by the way, that whole bevy, by analogy, if a citizen commits a murder, then certainly they would be subjected to criminal charges. But the victim's family also would have the option of bringing a wrongful death suit.
Were any of the wrongful actors involved in your case ever held accountable in any way?
The short answer is no. If I was to put a little bit of color to it, I would say that, I brought a federal civil rights lawsuit. One defendant was the medical examiner, but it was the county that employed him that paid the judgment. I also had 4 defendants in one lawsuit. So City of Peekskill, because it was their officers who coerced the confession and purposely didn't document certain witness interviews. So they settled with me. I brought a claim within that same 83 legal malpractice. They settled with me, and I went to trial against the polygraphist. But again, the entity that paid that was Putnam County. So none of the people paid anything financially. They certainly didn't face any criminal charges. There was no professional consequences. The most that could be said that happened was a few indirect things. So first of all, the prosecutor who had prosecuted me 2 weeks before I emerged, he suddenly retired and ran to Florida. And then once I filed the civil suit, the medical examiner suddenly retired. But that's the most really that happened. And the thing also I want to share is none of the people involved in what happened to me ever issued an apology. The only one that did was the actual perpetrator, but then to the extent that that had any value at all, he managed to ruin that too, because he mixed his apology with a lie. He claimed that had he known I was wrongfully imprisoned doing time for his crime, that he would have said something. But it was such a high profile case. Everybody in Peekskill was talking about it. Every time I went to court, it was a major media moment. So I don't see how it's possible that he hadn't learned that somebody was arrested and convicted for it.
What degree of culpability, if any, do trial judges carry in these cases that result in wrongful convictions?
A lot. So first of all, the trial judge has a gatekeeping function. They're supposed, before a confession could be used, for example, the trial judge has to determine whether the suspect was read their Miranda warnings or whether or not the statements were coerced. Most of the time, judges do not keep coerced false confessions out. They certainly didn't in my case, nor most of the other cases, which is how the wrongful conviction happened. And similarly, when there's an identification made, there's a Wade hearing in which the judge has to determine whether or not the lineup procedure was unduly suggestive. They rarely keep out suggestive identification. So they play that right there. They played a big role. Certainly the rulings that they make in the course of the trial. I mean, my trial judge, certainly the rulings he made, I mean, set the stage for me to be wrongfully convicted. So trial judges play a big role. And I also want to add that appellate judges play a big role in preserving those wrongful convictions. You know, that when you go to the National Registry of Exoneration and you read the short one pager, and it details the trial and then the post-trial, the proceedings, the appeals and efforts at overturning a conviction, there's so many red flags, there's so many indications that things were wrong, and yet the appellate judges kept on affirming convictions. And that's why by the time most people are exonerated, their appeals have long since been exhausted. So I don't want to overlook the role of the judiciary, not only in helping these wrongful convictions happen, but also preserving them. There's a tension in the justice system. There's two concepts and that really play into this. So one of them is finality of conviction versus accuracy. In other words, the competing ideas that, look, on one hand, you had your day in court, you lost. How long are we going to have to keep going through this? Is ever enough enough? And on some level of finality makes sense, but I think that whenever there's an objective reason to reopen a case, you should reopen it, because what good is a final conclusion if that's inaccurate? So that's one aspect. The second tension is proceduralism versus substantive justice. In other words, like in my case, when I lost in federal court, the fact that I was late 4 days, I forget about the lateness was caused by the call clerk. Just the fact that I was late 4 days, why should that have been more important than the legal and factual arguments that I was making? And yet that seems to be the preoccupation. So sadly, when trying to exonerate wrongfully convicted people, at about half the battle is not simply whether you have the facts and the law on your side, but whether you're going to get an objective hearing and decision from the judge. Are they going to honestly evaluate the claims and make a ruling that they're supposed to do, or is it going to be just a knee-jerk rubber stamp denial, which too often is the order of the day?
You mentioned the media a second ago. There has always been a strange relationship in this country between the criminal justice system and the media. Brutal murder cases, particularly in small towns, get media attention all the time. Right around the time of your case is when cases and trials began to hit television sets and things of that nature. How does media impact the criminal justice system? And is there a way to balance, right, the freedom of the press and the individual rights of criminal defendants?
Yeah, it does impact quite a bit. In academic learning, that's referred to as hue and cry. So basically, when there's prejudicial pretrial media, I mean, that can certainly set the stage for a wrongful conviction in a number of ways. I mean, first of all, it can certainly taint the jury pool. Now, jurors are polled and asked whether or not they have heard about the case or read it, but it's naive to believe that all the potential jurors answer that truthfully. So that's one way. At other times, I feel like if the media coverage is strong enough and it's prejudicial enough, it can actually sway the judge in which way they rule. I think that in a lot of high-profile cases, including mine, I think there was no way in hell that the judge was going to rule that the statements were coerced and then suppress them, knowing that there's no other evidence, and so the case is going to be over. I think the media coverage can certainly impact what type of sentence the defendant draws. I think it could also sweep up the prosecutor at times, although in other times it's the other way around. The prosecutors are the ones driving their prejudicial pretrial coverage. For example, Duke LaCrosse case and a false accusation case. I do believe in the power of the press and having open courtrooms. I think that's really important. I think that the way of striking the balance, the need for a fair trial of defendants' rights and not forgetting a presumption of innocence, but also with the press's right to report. I think that, well, first, I think that reporters, they should read pretrial motions, and you look at what a defense is trying to do. Are they arguing a confession is coercive? So based on what factors are they using to challenge an identification? Pay attention to the cross-examination, which is going on in the trial. And then also not reporting everything that the police and prosecution reports as gospel. I mean, I think it's better to refer to it as what they're saying and then mention what the defense is trying to show, rather than just printing it one way. And frankly, I think that defense attorneys don't escape culpability here. On one hand, they often give no comments, and schools of thought like, well, I try my case in the court. I don't try my case in the media. Yeah, okay, great. Congratulations at mentioning that truism. You're not making comments. And on the other side, the prosecutor and the police are, and you're saying nothing. So you're not defending your client in the court of public opinion. I think that that's very damaging. So I believe in defending your client both in court and in the court of public opinion. And I think that when it comes to doing wrongful conviction work on once a wrongful conviction has happened, I think strategic use of the media is critical. I think it sends a message to the judge, hey, the media and or the public are watching this one. Let me be just a little bit more careful in how I rule, and whatever we can do to have judges really pay attention to cases and give a judgment on the merits rather than the knee-jerk reaction, rubber stamp denial, I think is critical. So not just the media, but also grassroots tactics such as packing the courtroom, I think is important.
Well, lawyers do have to be careful. As you know, there are ethics rules around what lawyers could say to the media, right? Those rules are designed to prevent the influence of a fact finder by a media statement. So there are certain limits with which, or rather in which defense lawyers operate.
There are some limits, but what I'm saying is that to the same level way that like police, they're allowed to be like, one level of violence above what they're encountering. I mean, as a defense lawyer, you can see the extent to which the one side is saying things, and you could just meet that level, but not go overboard.
We select juries in this country through a process called voir dire, pronounced in different ways depending on where you are in the country, that relies really on a simple question and answer session, right? And obviously that opens the door for jurors to be dishonest. And it's often hailed as the best kind of system in the world. Obviously, the solution to having a juror who perjures himself or herself or something of that sort can't be to jail the juror, because that would defeat the jury system altogether and would dissuade folks from wanting to serve on juries even more than they already do. How do we fix that?
Well, let me say this. I mean, when they answer questions, I mean, it's supposed to be, I mean, some of the questions are supposed to be under penalty of perjury. So I think if they commit perjury, then they should be subjected to the same criminal charge that somebody else will. But I mean, beyond that, I mean, I think just doing this is hard to do because you have limited resources, but I mean, doing research to the extent that you can, but that really has to do with whether or not but jurors or potential jurors know any of the parties or witnesses in a case. I really don't have an easy answer to this. I do like the idea of the citizenry being a bulwark between the government and the defendant, and that's what the whole purpose, of a jury is. I mean, I have thought sometimes about the idea of a professional jury. I mean, people that have a knowledge of the justice system, whether on the policy side or even lawyers. But what the specifics of that are, what are the actual requirements beyond just vaguely saying that? How long would they actually serve? If we went that route, are we in effect creating just another ruling class of people, almost like a politician? So could be flaws in that too, but it's just a rough idea I've tied with, but I don't have an easy answer here for this one.
I want to talk to you about your period of incarceration for a bit.
Sure.
Jails
Sure.
in this country are designed to rehabilitate, at least that's what they say. In your experience, do jails rehabilitate?
No, prisons do not rehabilitate. Just we have a legal audience here, obviously. So difference between jail and prison.
Right.
So jail is where you go when you're initially arrested. The only people there are people that have not been proven guilty yet, unless they've been proven guilty and been given 1 year. Then they would stay in the county jail. Beyond that, prison is a state system. So if you're given 1 year and a day, you're in the state system. So everyone there has been convicted either by trial or by plea. So I do not believe that prisons are rehabilitative. I think that rehabilitation that takes place within prison is despite the system rather than because of it. If it really was about rehabilitation, and I'm going to make my case, if it was really about rehabilitation, then first of all, we would have prisoners who are from the city would be incarcerated in facilities that are near to the city. Those who are from upstate would be housed in facilities that are in upstate. The Department of Corrections does it the opposite way around, and that makes visitation more difficult, more expensive. And the reason why that's an indication is because family ties, community support are an indicator of support someone has, and people that have support on the outside, they're more likely to be able to transition to a crime-free life. So that's one thing. Second thing, we would have college and prison. Recidivism rate for college-educated prisoners is extremely low, and I saw people change. When I went to college and prison before funding was cut, and I think the reason is that number one, you're expanding horizons, and number two, you're equipping people for gainful employment. Third of all, we would have the vocational trades that were in the prison. They would have up-to-date curriculum. I finished the plumbing program, for example, got 6 certificates. Nearly all of my training was in cast iron and metal pipe. So when I came home, if I had decided I wanted that career, I would start at virtually the same place as I would as someone who had not gone through the program. There would be a serious effort at reducing prisoner-on-prisoner violence. The staff would be more professionalized. The verbal abuse and sometimes physical that goes on as far as between the guards towards the prisoners would not be allowed. I don't think that housing kids in the same facilities as adults is a good idea. So under the current law now, if a kid has been, like, I was charged as an adult. The crime was alleged to have been committed at 16. So I was sent to a men's maximum security prison at age 17. So I think 17 to 22-year-olds should be kept separate from adults. It's very dangerous, and the susceptibility to peer pressure and to be led down the wrong path is high. I think that people that have mental health issues should be kept away from the rest of the population because they're often taken advantage of. So all of those things, food. I mean, a lot of the food was either not fully cooked or it was burned. So food is not supposed to be part of the punishment. Improved medical care. I can tell you from firsthand experience that the prison medical staff, their answer to virtually everything was take some over-the-counter medication, Tylenol or similar medicines, and come back tomorrow. And it would take like a month or two before you could even actually see a doctor rather than just an on-call nurse.
Talk to me about your foundation, what it does, and what it's already done.
Sure. So the foundation seeks to free wrongfully convicted people. In other words, people in the same position that I was once in. And we work to prevent what happened to me from happening to other people through advocating for policy changes. So we already have helped free 14 people since we opened our doors back in 2011. And we helped pass six laws aimed at preventing wrongful conviction. So in terms of what policy changes we helped pass, so videotaping interrogations, we helped to pass that, although that came out with unfortunate exceptions. So sex offenses, drug cases, and homicides are carved out from the general rule that custodial interrogations have to be videotaped. So we helped to pass that. We helped to pass identification reform, so codifying into law best practices. Again, though, not all the best practices were incorporated into the legislation, but something was passed. DNA database expansion. We helped pass the Commission on Prosecutor Conduct. We helped pass discovery reform, and we helped to pass an expungement bill in Pennsylvania. In terms of what we're working on now, we're currently working on trying to free 13 people. We have those 13 active cases. We're pushing the following legislation in New York. We're pushing a bill which would get rid of the exceptions. So sex offenses, homicides, and drug cases would have to be recorded. Non-custodial interrogations would have to be recorded. There's a police deception bill, which would ban law enforcement from using deception in interrogations, recognizing that is inherently coercive. There's the Youth Interrogation Act. So if enacted, it would give 16, 17-year-olds and kids younger than that a non-waivable right to counsel. They would have to speak to a lawyer to explain their rights to them before the child could decide if they wanted to waive the rights and speak to the police without an attorney or a parent being present, keeping in mind that 16, 17-year-olds and kids younger often don't understand their rights. I certainly didn't understand my rights. Every time it came to that portion of Miranda warnings, which said anything you say can and will be used against you in a court of law, my mind went to what I saw on TV, and I would think, different civil court contexts, and I would think, court, what are you talking about? We're not going to court. I saw a lot of people there that would go to the parole board who were different people than when they were than 10, 15, 20 years ago when they did commit a crime. And look, they were caught, they were punished as they should have been. They paid a price. But I think that, once you've completed your sentence minimum, as long as, and if you can demonstrate that you've been rehabilitated based on your disciplinary record, based on vocational programs, then I think that people should be released. But I would see many people go to parole board and get denied parole based only on nature of the crime, which is something that could never change, and they would go to the board and be denied, order to serve 2 more years and go back again and have that repeated again and have that going on in a seemingly never-ending cycle of perpetuity. It's almost a complete abandonment of any idea of a belief in rehabilitation and a second chance. So the fair and timely parole, that's a bill that's being considered by the state legislature now. It would require parole boards to cite one additional factor beyond nature of the crime. And the companion bill, elder parole, which is a proposition that if a prisoner is 50 years old and has also served 15 years, that they would be given a parole board appearance, not a guaranteed release, like the fear mongers would like you to believe. It's simply an appearance to be considered, recognizing that, first of all, the age 50 is not arbitrary. That's per the Department of Corrections. If you're 50 years old and you've served 15 years, you're elderly, just taking into account the impact of incarceration on the body, on the health. While the prison medical care was terrible in general, it was particularly inept at dealing with the advanced geriatric needs of prisoners. So that idea is built into that legislation. In Pennsylvania, Pennsylvania is one of 12 states that does not compensate people who've been exonerated. So we're working on passing compensation there. And in California as well, the same landmark bill that we passed in New York, the Commission on Prosecutor Conduct, we're working on passing that in California. The theory is that in general, when both New York and California pass the same legislation, often the other states follow. So we're hoping it'll set off a chain reaction. All we want is accountability. Okay, we're not against the prosecutors. We're even not against the cops. Okay, if you're in those professions and you do your job and in an ethical, legal, transparent way that respects all state and federal constitutional rights, I have zero problems with anybody. I'm not a defund guy. I think the world would actually be, kind of scary without the police. I mean, what are we going to do? We're going to go back to the days of Wild Wild West. I mean, even I wouldn't advocate for that. But at the same time, I do advocate for accountability and consequences. And no, it's not a few bad apples. I think that law enforcement rhetoric, that knee-jerk response whenever law enforcement is caught doing something, just a bad apple. No, it's not. It's too many of them. Stop saying that because you're denying that there's a problem. Okay, but at the same time, it's not everybody either. There's quite a few good people in those professions as well. We just, what they say, when you see something, say something. I say, well, let's apply that to law enforcement too. So we need the good cops to blow the whistle, to turn on, to force the dirty cops out of your profession. Same thing as the prosecutors. But as the people in those professions, again, that are doing their job in a legal, ethical manner, hey, I welcome you and essential part of the system.
Jeff, in light of your background, your time is more valuable than that of most. I appreciate you giving me some of your time today. Thank you so much.
Thank you very much for having me on.